Good morning. To be on a panel with these outstanding members of the legal community is a real pleasure and privilege. And I thank these members of the plaintiff's bar because they keep the defense bar in business. And thank you both. I've had the good experience in the early mid-60s and early 70s to have run a motion picture production company, and was involved in the initial stages of videotaping. In fact, met with the Supreme Court in order to get an approval for videotape depositions. And that's the days when we talked about when you had to have the running numbers of the time because of editing. You wanted to know if something was taken out or left in. And also the determination that you had a fixed lens on the witness so that the operator couldn't zoom in, change focus, and do things that would become a sales tool. What you were trying to show, of course, is the actual witness and the testimony. In connection with the use of video for mediation, arbitration, trial, one of the things I think you have to understand is you have to know your audience. Who are you presenting the presentation to and for? What you might want to present to a jury is not necessarily what you would present to an arbitrator or a mediator. Most of the mediators and arbitrators in town have 25 to 50 years of experience. They've been there. They know many of the things that a jury would not know. And you want to be careful in how you make your presentation. I represented nationally Terminix, the pest control operator. You notice I didn't say exterminator, they were pest control operators. And in cases across the country, the claims usually were that the air levels of the chemicals that were put in for termiticides were causing cancers. And the issues, people would move out of their homes, and air levels were done, and people did not understand how termiticides were applied. I went down to Memphis, Tennessee, and produced a videotape on the application of termiticides to homes. And it was done for the purpose of showing it to a jury. In the many, many cases that I tried across the country, never once did I ever show it. However, in pretrial conferences, I changed the minds of many judges on how they viewed the case based on their knowledge of how the application was done, and cases settled. So that where it was made for the jury, it was shown to the judge, and it had the effect that we wanted to have it have. I also represented a large chain of restaurants that did big bar business. And dram shop litigation for serving people who are visibly intoxicated. There are a lot of cases around. This particular restaurant chain made a videotape which they were going to use as a training tool on how to serve alcohol. They sent it to me because of my background. I reviewed the tape and made the following comments. One, don't use it. I thought it was poor taste to have Seagram's as the sponsor. Secondly, as you looked at the various frames, all you saw them doing was serving alcohol. I said, I don't see Sprite, Coke, Pepsi. And they said, well, you mean we have to pay to redo it? I said, let me tell you something. A quality plaintiff's lawyer is going to ask, do you have any training films? Your answer is going to be yes. They're going to say, I want to see it. If they see this, you've lost your case. So they had to redo the entire presentation. Again, the audience to whom this was going to be shown had to be determined. One of the things that I noticed in the day in the life of for Erica, which I thought was one of the better ones that I have seen. There were a number of things in there that I thought made sense. One, they did not impose upon her and the intimacy of her life. They showed the shower chair in the shower. They did not show her being wheeled into the shower. They didn't show her in a bathroom setting. They were very careful not to do that. Juries get turned off by things like that, having spoken to jurors. And they also showed things that she could do. She was holding a pill. She could hold the box of juice, though frequently she didn't. They weren't just showing you negatives. They were showing you positives as well as negatives. Yet the whole concept of her day was well presented and made sense from the point of view of the use of such a video presentation. There were not a lot of tears shown. I recently had a case where there was a death, and the family of the plaintiff, brother and sister, were on screen for a very long time, basically crying. The unfortunate part is they hadn't seen their sister in 4.5 months while she was dying. And these people as plaintiffs would have gone nowhere in the courtroom. After the mediation, the determination was made they weren't going to use that. They were going to get a guardian instead of these brother and sister, based on what was shown in the video. And at a second mediation, the case settled once they were out of the picture. So it's important to know, again, what is in the video and what is not in the video. And I thought the fact that it was very clear, there weren't tears, there was a direct, honest, accurate presentation, which is important. And also the length. That was not overly long. You want to be short. You don't want an hour. You don't want 2 hours. Because jurors, you lose them. And here is a terrific presentation, and the things that Marty showed, the clips, are very, very important. When you find a mediator getting a DVD, and I get them in many, many cases, believe me, I don't see them in cases worth $50,000 or $100,000. I do see them in cases worth several million. I have one coming up Monday where the demand is $29,750,000. And I have reviewed the video. The attorneys send them to me as the mediator in advance so that I can look at them at home. I'll give you an example of a situation where that was not done. For some strange reason, an insurance company in Chicago has a case in the Virgin Islands, and they brought it up to Philadelphia for me to hear, and I still don't know why. The demand was $36 million on a brain-injured child who fell out of a window and had a brain injury. The issue in that case was, one, whether the window was defective. It was what is called an egress window that opened out. The child was sleeping next to the window, rolled over, and rolled it 12 feet down to the cement ground. The other issue was whether he had traumatic brain injury or he was some other problem. The plaintiff's counsel flew up from the islands. There were about 12 people in the room, and he said, I want to present a DVD. Now, the defendants had already seen it. They had not sent it to me in advance, and why we had to spend the time doing that. And what was the DVD? It was two very well-known doctors, one from Princeton, one from Harvard, who were talking about their findings. What was interesting to me is the doctors were sitting in the room. I was trying to figure out why I needed to look at a video of these doctors who were there to tell me what they were going to tell me on the video. They paid a great deal of money one, to make the video, and two, to bring the doctors down. And what they basically said to the doctors, is that what you said? Yeah. Is there anything you want to add? No, that doesn't. That says it all. That's a mediation setting where you don't need the doctors if you have the tape. And if you have the tape, send it to the mediator in advance so that they can sit at home, put it on their TV, in their DVD player, and look at it. Carefully evaluate it so you know what you're doing. Many of the tapes that are made for the purpose of influencing the audience. In a mediation setting, they are really not trying to sell the mediator, but the representative of the insurance company who is brought by counsel to sit in on these major cases. Now, they can send those to counsel in advance. They'll have the opportunity to review them. But if they show them in the mediation room, they're trying to sell the carrier who is going to put up the money, not the mediator, whose job is not to evaluate the case, but basically to evaluate the settlement potential and see if you can get a settlement. And these tools are very helpful. Again, if you are making a video for use at trial, you may want to bring a shortened version of that to a mediation setting for a different purpose. There are things that counsel can put before a mediation or a mediator and the people in that room that might not be allowed in a courtroom. And they want to make certain presentations. That is one way to do it. As far as a mediator is concerned, usually the mediation memorandum with photographs, still photographs and the like, can suffice. But again, what is your audience? Who do you want to show? You don't want to gild the lily. You don't want to overplay. You want to be short, accurate, honest. Because if you find that you are not, it can have an adverse effect. Defendants use video frequently in surveillance. And surveillance is a wonderful tool. When a plaintiff says, I cannot raise my arm, and you see them working like this, it doesn't have a very positive effect on a jury. And if you find a plaintiff lying in one aspect, they may be lying in all their testimony. So surveillance video is very important. But what is important for plaintiffs to understand is that when there is a surveillance, you should ask for outtakes. In other words, those films which were taken and not used. There are some wonderful things in outtakes. They may be out there 4 different days, and you'll see 3 days. And on the 4th day, the plaintiff is in severe pain, unable to do things, but for some reason that was not shown. So defendants use that frequently. Now, there was a case recently where a defendant produced animation on a vehicle truck accident. The truck was pulling onto I-95 from the airport. The plaintiff's vehicle came in and just rode under the truck, taking the top of the truck off, and unfortunately, the top of the plaintiff. A very, very drastic and severe injury, obviously resulting in death. And the issue was whether the truck should have pulled out or not. The defense was that they had plenty of visual warning. There was clear road ahead. And they did an animation in which they showed the vehicle moving at 3 different speeds. And the only speed in which the vehicle could have been in the position that it was at a very, very high rate of speed. And it resulted in the case being settled at a rather nominal sum for the injuries that were involved in the case, the death. So animation is outstanding, and you saw a sample of the animation in Marty's presentation. In cases of complex equipment, in your product liability cases, you will frequently have video done of the equipment and the operation of the equipment, and in there is animation as well to show the movement of the product. In this particular recent case, it was steam that when they undid a valve, it blew out and scalded the operator. And it was a complex piece of machinery, and you open R and W and A and B. You didn't know where all these pipes ran, so they showed it as an operating piece of equipment, and then they did the animation to show the movement of the steam and how the accident occurred. That is very educational for a mediator or an arbitrator, because an arbitrator is the jury. And many of the things that an arbitrator can evaluate, which a jury may not be allowed to see or not to see, is extremely helpful in understanding complex equipment. Just saying it or trying to express it in words does not necessarily get the point across, but the film and the video does. In a day in the life of, one of the things that I have noticed, and I noticed in this one, the surroundings in which the plaintiff was located were clean, neat, and pink. But what I have also seen in one where a gentleman was in a wheelchair, were beer bottles, beer cans strewn around the room. Really, it looked like a hovel. This did not come off well, and would not have come off well if shown to a jury. And it had an effect on the amount of the settlement. So you have to be concerned about the surroundings. Where were you shooting it? What are you seeing? And I like that part about the pink, because it had a certain emotional impact on the audience. And that's what you're trying to do. You're trying to tell a story honestly and in good taste. Many attorneys now are trying to use portions of videotape depositions in their opening to a jury. Some judges allow it, some do not. In a recent case, plaintiff's counsel said the defendant did the following. I'm not going to tell you that. The president of the defendant company is going to tell you that. And they played 2 minutes of the deposition. After the opening was over, and there were several of those clips, the case was over basically. It tried for a few days and settled for a very substantial sum. As I say, not every judge will allow that in. Some do. I don't know what the future of that's going to be. I don't think it's inappropriate, because if what you do in an opening address is say, ladies and gentlemen of the jury, this is what I'm going to prove. What you close with is, ladies and gentlemen, this is what I have proved. Now, if you're going to prove it, and you have it, I think it's appropriate to show it. So I don't know where that's going to go, but that's a use of the videotape deposition in your opening in a trial. I think it's important, by the way. I'm a very real big fan of video, but you can overdo it. I've always suggested that if you have video, have live witnesses as well. If everything you're presenting is a video deposition, you will often lose the jury and their interest. People are accustomed to sitting and watching television. And what you are doing in a courtroom, even in the very upscale Philadelphia courtrooms that have been built to handle the new equipment, you can overdo the amount of material that you do with videotape. Many doctors do not want to take the time to come into a courtroom. So they are videotaped so the testimony is preserved and brought in. It's worth the expense, the time to bring in certain witnesses live. But there are certain things that you can't get where you must videotape. And under some of the new procedures, I was recently in an argument, I was given a courtroom to have a hearing, and the witnesses were in California, and they were done over telecommunications, and it was like having the witness in the room. But that then became a live witness for all intent and purpose. The videos that are presented by counsel, in effect, can be their opening. If you have an arbitration and you had a memorandum presented, whether you were a sole arbitrator or a neutral arbitrator on a three-person panel, you've seen the memorandum, you've seen the tape. Smart lawyers will not make long openings. They have presented their case to you, which they've had the opportunity to carefully craft and submit. Obviously, in a closing, they want to close. The testimony does not have to be as lengthy because the mediator and or arbitrator has read all of the medical reports that have been submitted. It shortens the trial process, it shortens the mediation process, and it is very, very effective. So careful presentation of your material is really important. Again, video, back in early 70s, we started to videotape thoroughbred auction sales. They had been done on audio, and there were lawsuits frequently after the purchase of a thoroughbred horse. The horse I bought had white stockings. The horse you delivered didn't. The horse had a white patch on the nose. The horse you delivered didn't. We're not going to buy it. When we went to video, you saw the horse. If it had white stockings, you saw that it had white stockings. If it didn't, you saw it. And it avoided about 70% of the litigation that came out of thoroughbred auction sales. So there are so many aspects of the use of video. In domestic relations cases, which I hear, I have never seen a video. It'd be a little difficult. They'll fight for you personally. You don't have to have it on video. On real estate cases, you rarely will see it. You see it often in construction litigation. In contract litigation, what I have seen is the contracts shown, and then what they do is they take the section of the contract they want you to be familiar with and they bring it out. So what you would do in a courtroom, perhaps, is using it on a large presentation board where it's yay big, the paragraph that you want. But if you're trying to do it in video, they do that where the terminology comes out. And in fact, in the Terminex tape that we made on the application of miticides, we took the label as part of the presentation, and the warnings we brought out so they filled the entire screen. Do not bomb, or this type of warning, or whatever you might have, so that the effect that you have and the ways that you can use it are many. And I really compliment counsel who have done this. On Monday, I have this rather large case, and what Marty was mentioning in the particular DVD that I have reviewed, it's an amputation originally below leg. After many operations, it was above knee amputation with one of the most horrible looking remnants. It's not even a true stump. And the video very clearly shows us the particular injured individual has 3 different prostheses that have to be worn at different times. And while you can talk about that, you really have no concept of what it is unless and until you see it. In that case, they did exactly what Marty mentioned. They had photographs of a family playing, or 4 children, the father playing with the kids, playing baseball, running. They had the wedding ceremony where they turned from the altar and walked up the aisle, where the husband, plaintiff, said, "I think my wife has suffered more than I." Nobody was crying. You could see they were tearing, but they were presenting themselves in a way that anyone who sees it must be moved. What that tends to do, and what defendants want you to understand, they want to talk about the liability. What you're trying to show is what effect this injury has had on the plaintiff. And defendants are really helpless to do much about it. Shannon said that when he did his questioning of the witness, he was making some mistakes, and both Marty and I said, nobody, no defendant will object in the middle of that. You can get away with things, but he did it tastefully, and he didn't really go out of bounds. And it wouldn't have made much difference. All you can do is irritate the jury or an arbitrator by interrupting something like that. Now, if it would get out of hand and gross, then you would do something, but normally you would not. And generally speaking, the use of mediation before arbitration or trial is really very, very helpful. Many lawyers say, gee, we tried this case, we could have done better in a settlement. My comment to them is always, well, why didn't you mediate first? And if you don't like what happened, then you can try your case, whether in an arbitration setting or in a courtroom. So there are tools to be used, and audiovisual are one of the great tools that have come around. Thank you.